late because she had some work to do. So Aman, thank you very much for being part of the symposium, and I'm looking forward to the session for sure. And what I thought was, I mean, what I've been doing is just a short introduction on the uh, symposium, not too long, so you won't take your time on major time on that. And then, of course, I've stopped talking about how to find out about what I'm doing. I have said enough on that. That go to mediatorvikram.com, go there. So the idea being mediation legislation, the how, what, when, where, which, who, why. I keep saying, if you have any other questions to add to it, please add more questions to it. Let's just question everything. Let's not take anything that, okay, this is what it is, and that's it. Let's go one step beyond that. This is what it is, but this is the way it should be, whatever things. And then in the workshop on the 19th, we'll maybe have more discussions on that. So that 50 and 30, you can add a plus to it. Now there are 50 plus and 30 plus countries there. So that little addition can be done. So, Aman, it's all about you, a little bit about yourself, and then let's hit the topic, please.
Well, I've been engaged in mediation since 1998 when I started teaching mediation at the Delhi University, and practicing mediation along with my professional practice as a lawyer. So I'm not a full-time mediator. I'm essentially a lawyer practicing in the Supreme Court. I'm associated with the mediation centers of the Supreme Court and the Delhi High Court. And as I said, I've been teaching mediation from '98. It's been almost 25 years now. And I teach mediation in different faculties in India and abroad. And the focus of my teaching is building capacity building, teaching mediation skills as opposed to theory of mediation. And so I've had the occasion to draft the rules for mediation for bodies like the FICCI, for PhD chambers, make the module for the Bar Council of India for their bar exam, which is held annually. Um, and so that's about it. I mean, that's my, and of course, I've written on mediation and more critically on the mediation bill which is before Parliament. So that's more or less what I have my engagement with mediation.
But look, I started calling it the X bill. With Chitra also, when we were discussing, let's call it the X bill. Luckily, it's gone back from the Parliament. Gone back. It definitely should go. If it has to go, it has to go in a different form for sure. So that bill, for it's an X bill. Let's hope that a lot of things changes. But little bit of background you'll have to tell us about legislation in India, various kinds or whatever we have, and then we'll.
You see, we had conciliation mediation is the same thing, but we had conciliation in this country, I mean, for even before independence in some of the statutes. But we had the 1996 Conciliation Act, which talked about A asking B to come for conciliation, giving a notice, 30 days period. If they agree, well and good. So there were all the elements of a voluntary process, self-determination, party autonomy, etc. And of course, the role of the conciliator was set out along with the status of a settlement agreement, being that it could be enforced as though it was an arbitral award, could be enforced as though it's a decree of a court. So it was binding, and you had confidentiality at different levels. Um the settlement agreement was confidential except to the extent of its enforcement. Whatever was said in conciliation could not be cited out. What was told in a private session to be confidential could not be revealed to the other side. A conciliator could not be called as a witness or be a lawyer or an arbitrator unless otherwise agreed by the parties. So there were different levels of confidentiality. So all the rules of conciliation and mediation, as we know now, were captured in the Conciliation Act. Of course, there were things which are missing, things like a kind of body to give accreditation to conciliators, setting of ethical standards, disciplinary proceedings, recognition of, I mean, or actually more specifically of community mediation, online mediation, those things were not really there. So, but the framework was such that it was, I would say, far ahead of its time in many ways. And so we had the Conciliation Act. This was in 1996. Then Parliament tried to introduce Section 89 in the Code of Civil Procedure, which basically told the court that should a case come before you, refer the parties to different form of ADRs. And there they use the word different conciliation as well as mediation. And so when the Law Commission said, why are you using two words for the same process? The answer was that mediation is more used in the sense of a court trying to effect a compromise. And then Law Commission said, that's a novel idea. You don't need rules for that. So delete the word mediation. Unfortunately, the Section 89 was enacted in the same form as it was introduced. And we had two words. So Supreme Court was struggling in Salimbar's case, 2003, 2005 judgments, that what is the meaning we need to give to the word conciliation as opposed to mediation. And they, I would say, invented a distinction which is without a difference actually. That conciliation is the more proactive form of mediation. But the Supreme Court itself, in AFCON's judgment 2010, said conciliation and mediation are synonymous. That's what the Law Commission has been saying. That's what the Singapore Convention says. That is what the Mediation Bill says. Mediation Bill now subsumes the Conciliation Act. So so if we already have a standalone law on conciliation, though inadequate in some respects, there's still an argument for a fresh standalone law on mediation, which assumes conciliation and adds many other provisions. But as I've testified before the parliamentary committee, the bill is inherently incoherent, it is defective, and we just need to go back to the drawing board. We can't have a bill like this, which in my view would destroy the mediation movement in the country, as opposed to encouraging it or mainstreaming it.
Absolutely. But also, Aman, a little bit about the other legislations also in relation to mediation, like in the Companies Act and
No, I
MSME
mean,
and all that.
you see, conciliation mediation are there throughout many statutes. I mean, whether it's matrimonial cases, for example, you would have Family Courts Act will provide for it. You would have the Hindu Marriage Act, which provides for it. You have the Gram Panchayats, Gram Nyayalas Act, which is basically taking, mobile courts to the below the district level, to villages, and they say that we should try to do conciliation. You would have it in the Consumer Protection Act. There would be, for Motor Vehicles Act, they were saying have conciliation. That's where the mediation. That's the reason why the Supreme Court suggests to have a mediation law. For in Motor Vehicles Act, there was no provision. For labor disputes, industrial disputes, pay of conciliation officers. So it's across the board. You would have mediation conciliation, which have been recognized in one form or the other. Even the Legal Service Authorities Act, for matter, you have Lok Adalats, which are the closest to a judicial settlement in other countries, where the presiding officer will deliver an award, but that award is basically giving approval to a settlement between the parties. So that is, they're still trying to come to a settlement there. A permanent Lok Adalat, which is meant for public utilities, is slightly different, where it would start on the adversarial note. You would have pleadings, etc. The PLA, permanent Lok Adalat, would try to get into resolving the matter through conciliation mediation. If that fails, then the court would go back, the PLA would go back into the adversarial mode and decide the case on merits. So it's a different permutation combination. And then you have provisions, whether it's ombudsman or for Lex City, for instance. So there's a variety of legislations where you would have different strands of mediation conciliation introduced as an alternative form of dispute resolution. So that is there, very much there in the law. But to consolidate or to lay down a standardized procedure, you have the 1996 Act, where you could fall back on those what is meant, what is out there. Some provisions are derogable unless otherwise agreed by the parties, etc. But at least you had a template, and which is the argument. Even the committee does the parliamentary committee does acknowledge that you already had a standalone law for conciliation. Do we really need a fresh standalone law for mediation? They say they still argue for it. I don't understand why, but they still argue for it. But so you had conciliation and mediation in one form or the other in different statutes. But the only standalone law on conciliation is the 96 Act.
The idea was to, because look, I mean, of course, you are familiar with all the laws, but here you're trying to put it out there that what is the kind of legislation that countries are doing. So that's why I thought let's first talk about what exists, and then
Mhm.
we can from there take up as to where it is going, where it should go. I think that's why. What we left out maybe, of course, was the Companies Act, which talks about a
Yeah.
panel there, and they have that process there. So that's another place
Yeah.
which we have that.
Yeah. So there's several other statutes I haven't mentioned.
Yeah,
There's
please.
several other statutes which they talk about, even if you go into Workmen Compensation Act. You know, there are several levels at which one can talk about how to resolve, even for banking matters. There's a whole procedure laid down. So this is not, I'm not exhaustive on the statutes, but the point is that they all talk about, well, this is the way you do conciliation. This is your provision for conciliation, but how to go about doing conciliation? What is the role of conciliator? That is what's crystallized in the 96 Act.
Yeah, because even the Posh Act also talks about conciliation. It's mentioned there also.
They say yes. Before you get into, in fact, I find that a bit unusual, but they say that before you actually take action on the complaint of a complainant who's accused, who's alleging sexual harassment, try to see if you can, they can have an amicable settlement. So that is something which is, to my mind, is a bit strange. But you do have that provision also there.
Yeah. So basically, there is a lot of places where the word comes up, and largely, of course, conciliation the word has come up, but mediation and conciliation have come up in places like the CPC, even in the Arbitration Act, Section 30 has both the words, and of course,
Mm.
the MSME has by mediators and conciliators.
Yeah.
So there are a lot of places we have all that. So now what we are look from the court system, if you want to talk about how it is working there, how it works, a little bit about that, as to how that process goes and what is really happening practically on the ground.
You see, the thing is that in India, private mediation or private conciliation has not really taken off. We have institutional mediation or institutional conciliation, and there are these commercial bodies, like I mentioned. There are consumer courts. There's the Delhi Government Mediation Center. Even in 498A, crime against human cell, they have a mediation center, conciliation center. So you have those institutional mediations, of course, then you have the court annex mediation. Um, the problem, and I think the court next mediation is doing well in the sense that it is getting traction. You are having people who get converted to mediation once they come to the centers, and there is at least in cities like Delhi, there is substantial success in resolution of the disputes for whatever the reasons may vary. Why there is the success may not be for the best of reasons, but there still one can say there is movement. The issues which I have with this kind of system of is segregating court and mediation on one side and other institutional mediation or private mediation is that our laws have created artificial and varying status to a settlement agreement. As per AFCON's judgment, if a court refers a matter to mediation or conciliation, more particularly to mediation, it needs to come back to the referring court for the court to dispose of the case as a decree of a court. To pass a decree which gets then executable. So at best, that a settlement agreement has the status of a compromise application. Similarly, if a matter is referred to the Lok Adalat, then the award must come back to the referring court for the court to pass the decree in terms of the settlement. So whatever is being referred by the court needs to come back to the court for it to get a status of a decree. In a private mediation, private settlement agreement, the settlement agreement, a conciliated settlement agreement itself is a decree of a court. A private mediated agreement today is like a contract which can be specifically enforced. So the process is the same, the dispute may be the same, the parties are the same, there's the same settlement agreement, but if it is in a private setting, mediator settlement agreement, it's like a contract. Conciliated settlement agreement, like a decree of a court. If it is a court referred matter, regardless of whether it is before the local adalat or before the mediation center, it is at best a compromise application. Decree of the court yet has to be passed. So you have varying legal status of a settlement agreement depending on whether it's in a private setting or a court setting, and that's ridiculous.
Absolutely.
The further complication is that if a settlement agreement contains matters which are beyond the subject matter of the suit or the case issued over the court, to that extent, the settlement agreement is a decree of a court. But to the extent it falls within the subject matter, it has to be made a decree of a court. So that is yet another odd situation which you are faced with. So these are artificial distinctions. The way an arbitral award, the way a court refers a matter under Section 89 for arbitration, it goes outside the stream of the court. It becomes an award. Can be executed as a decree of a court. There's no reason why the court there's no reason why once some court refers a matter for conciliation or mediation or to the local adalat, why can't it straight away be a decree of a court? Why does it need to come back to the referring court?
Which is actually Section 89 in that sense is saying that okay, you can opt for conciliation, so you're actually going out of the court system, and that by itself definitely that settlement agreement is as good as a court decree.
No, that's not what the Supreme Court says. Supreme Court has construed Section 89 to say if a matter is referred for arbitration, it will be governed by the 96 Act. It need not come back to the court. You need the consent of the parties for the matter to be referred for conciliation. If the matter is referred for conciliation, it has to come back to the referring court. It does not go out of the stream of the court. Similarly, if a matter is referred to lok adalat or is referred for mediation, the matter, if there's a settlement, has to come back to the referring court.
So because I think we'll just have a look at that, because I think AFCONs I felt had said that you come back to us only in a certain situation, not, otherwise. Because
No, they do have a look at it. And AFCONS has another very incomprehensible consequence. They've interchanged the words between mediation, judicial settlement, and Section 89, as a result of which a mediator in a court and ex mediation is to be deemed to be a lok adalat, complete with powers under Section 22, which talks about recording evidence, summoning witnesses, punishing people for perjury, etc. It's inconceivable to have a mediator being treated like a lok adalat. It runs against every principle of mediation. But that's what the law is, which I was hoping would stand corrected in the mediation bill. However, the mediation bill also maintains this distinction between whatever is being done through the court as per court rules, that will be outside the ambit of the bill, outside mediation law, lok adalats, Legal Service Authorities Act, those rules will apply. So this mediation bill effectively applies to private mediation, whether ad hoc or institutional. It cuts out exceptions for court and court mediations or lok adalat mediation. So we've been perpetuating this error of AFCONs in the mediation bill. And that again, the committee testified to that effect, and the committee has taken note of it and has suggested remedial measures as to that you have to get whether we need these kind of artificial distinctions. Can you have different legal status of a settlement agreement purely on the basis of whether it was arrived at in the private setting or in the court setting?
Because in terms of the AFCON, my only thing was that basically their concept was that if the settlement does not take place, then you come back to us. That is what they had said.
No. It says the settlement must come back. The settlement must come back to be disposed of, and then there will be a decree which will be passed. At best, it would be a compromise application.
So this is what it says. It basically says that As contrasted to arbitration, when a matter is referred to conciliation, the matter does not go out of the stream of court
Precisely. It does
process
not go to stream. It has to
permanently.
come back.
Yeah. If there is no settlement, the matter is returned to the court for
Yeah,
mediation.
but
So
if you see
if
further down,
hmm,
they lay down when the matter must go. If you see the conclusions of it, they say whether conciliation, whether it's a mediation, whether it's lok adalat, it must come back to the court for the referring court to pass an order disposing of that case, and then it becomes a decree of a court.
yeah. So no, that's why I say that this is something where the Supreme Court, look, for me, so how well the Supreme Court was assisted in that judgment, of course, that by itself, we don't know. I mean, what happened,
Yeah,
what the things were put together. But the important thing for me, the two-word theory for me is that both the words are mentioned, process being the same. That if you want to stay in the court process, you've got mediation, that word is required, and you want to go out of the court process, that's conciliation, because that settlement agreement is anyway as good as a court decree, so it's a outside process. That's the way these two words and I am also looking at them from the section 30 perspective also, that
yeah,
you want to stay in the arbitration, it's called mediation. You want to go out of the arbitration, it's called conciliation. We have a provision for it, and the settlement agreement is as good as a consent award, so you don't have to come back to the arbitrator. So I'm just reading those two words only because I still feel that those two words are required today also, because of the fact that if we say there's only one word called mediation, so in an arbitration, we are going for mediation, and you have a standalone act on mediation. So which means you've taken advantage of that act. And once you've gone into that act, it means those provisions apply. And at the end of it, what the settlement agreement is anyway as good as a court decree. Can you then come back to the arbitrator and say you pass an award? So those are questions which
no,
might
no,
come up.
I think that's, I mean, I would slightly differ with the interpretation. What the Arbitration Act basically talks about an arbitrator, that is not inconsistent with arbitration for the arbitral tribunal to recommend or to encourage parties to come to a settlement and to have a consent award, which would be enforceable as a decree of a court.
Yeah. And
So that is something which an arbitrator can do regardless of Section 89. That's under the
no,
Arbitration Act
no,
itself.
no, in the
And
arbitration,
when a matter is being referred by, under Section 89 to arbitration, then from the time of reference, the Arbitration Act will start applying and there can be a consent award, which would then be enforceable as a decree of a court. That is one proposition. But where a matter, that is an arbitration, that's where it goes out of the stream of the court. But when it comes to conciliation or mediation or lok adalat, if you go through the entire judgment, it is very categorical in its view in saying that for conciliation you need the consent of the parties, for mediation and lok adalat you don't need the consent of the parties. But in all three circumstances, if there's a settlement agreement, it needs to come back to the refereeing court for us to be decided. The further twist they give is that, of course, if any of these relate to something which is not the subject matter of what was referred, then that to that extent is a decree of a, but for the rest of it, it must come back. And also the procedures being suggested as to when a matter should go for arbitration, when should the judge say go for conciliation, when should the judge say go for mediation or go for lok adalats. Even those criteria or some kind of indications have been laid down to the referring judge. So be that as it may, the point is very simple. Of course, this kind of issues will finish off with this bill which says mediated settlement agreement will be also enforceable as a decree of a court. So with that, hopefully that to that extent of a mediation conciliation difference will be resolved. But by retaining court annex mediations and lok adalat on a separate footing, the rest of the problems which we're facing now of varying legal status of a settlement agreement will remain. And to add to that, we now have provisions in the bill which talk about community mediation, and which say that a settlement agreement which is arrived in community mediation will not be enforceable as a decree of a court. So that's yet another layer which has been added on by this particular bill. So, I mean, if we're creating a maze, we need to simplify our laws. We are creating a maze by which a person who's not well versed with the mediation provisions would not actually know whether the status of the settlement agreement.
but I'm going to still push my two-word theory, because what I was not, I mean, when I was talking about section 30, when section 30 is talking about the words uses the word mediation and conciliation. I'm just using it from that perspective, that why were they used? Because I feel this was the provision. These provisions were there. They were thought about. We were far ahead of our times in the way we looked at even MEDAP, because today you're talking about MEDAP, and of course this is 1996, and this is all the provisions are there. So why I'm reading these two words in this act itself, in the Arbitration and Conciliation Act, Section 30, is for me to why these two words are required today also, is because if you want to stay in the arbitration, the word mediation is there. You want to go in a standalone provision. Okay, this conciliation is part of the arbitration and conciliation. For a moment, it was not part of it. It was another provision. Doesn't matter. The point is, you had an option of going out of the arbitration and not come back to the arbitrator. Because the thing is, finally, let's look at it from the people who are in dispute. One, do they really want to come back to the arbitrator to pass a consent to what? There's a cost to it. There's a time factor to it. When in conciliation, they're already getting that. You don't have to get them back. So they've got that provision. But they know if they feel that they want to use the New York Convention, they use mediation, stay in the arbitration, come to the arbitrator, passes a consent award, and they use the New York Convention. So I'm just thinking.
There's no problem there, but but also you have to wonder. But at least what I strongly believe, uh, having done mediation on a regular basis, is these are all academic, hypothetical differences, which I would go as. I mean, when I'm doing a mediation or conciliation, I'm doing the same thing.
Exactly. It's the
From the
same thing.
performance skills point of view, if I in my settlement agreement, I'll be in the mediation, Delhi Mediation and Conciliation Center. We call it Mediation Conciliation Center, and we have pre-trial matters. We don't use the word mediation there. We use the word conciliation there. It's on the 100-page stamp paper, and we
But
use the word conciliation, and it's executable as a decree of a court. If I write the word mediation, it will be like a contract.
but
It is as ridiculous as that.
but tell me
So
something, Aman.
what you use, the status will depend on that. But from the performance skills point of view, I mean, I differ a lot from the theory behind mediation, all this thing of evaluative mediation, non-evaluative mediation, transform mediation. I may be doing all three in one session in a mediation.
Exactly.
So these are all distinctions which actually break down when you're actually doing mediation. I mean, of course, there could be conceptual difference of what should be a role of a mediator. Should be only a postmaster or postman communicating proposals, or should he have a more active role in it, or should he try to bring restorative justice practices to convert negative emotions into positive emotions to heal people? They may be, depending on the nature of a case, the role of a mediator may need to adapt the role. So you can have these artificial distinctions. But I, for one, um, use my standpoint to be that of the performance skills or the skills required to conduct a session as a third party neutral, to get the parties to come to a settlement. And from that perspective, I find most of our curriculum, most of we teach, the way we teach, is more academic oriented as opposed to learning by doing sessions or building the capacity of a mediator to adapt to the situation of that particular conflict.
But I mean, I've been requesting everyone. I'll request you also and Rafaela also. What if we do away with the word parties? We call them participants, because
Yeah.
parties comes from the adversarial system, comes from the court system. So I mean, this came from the World Mediators Conference. We had a session with someone who works in community mediation in the US, and she says we don't use the word parties. We say
Mm.
participants. We don't say opening statement. We say orientation, because those words have come in from that process, and in that sense, sometimes words make a difference.
Yeah, of course.
We were
Fair
into
enough.
terminology in that, so sometimes words make a difference.
Yeah, yeah, fair
But
enough.
but the only thing the thing is that, I mean, this is also a problem I have with you people who are doing in the mediation centers in the courts for free. That's another issue. That's another issue, because you said, I mean, in the Delhi, I think the mediation center decided that even matters which are not in court, like you were saying, these matters which are not, I mean, not even, there's no concept of them filing also, you can come to us and come for conciliation, and something nominal they have to pay. So I was telling, I think Mr. Panchu or Mr. Panchu, that look, what about people like us who want to make a livelihood out of doing this work? And here you people are doing it for free. What is going to happen to us? So request to all of you, please don't do it for free. But in connection with legislation, how do you look at the way it's structured, say in the Commercial Courts Act? the way if the fees that the legal services authority have taken out in terms of this much you will get if it's not settled, this much you will get it settled, and some nominal amount there. So I'm looking at legislation from the perspective of the mediator also, their interest and the fees, something about that aspect.
No, I mean, I completely agree that mediator who's putting the number of hours and must be paid, and there's no doubt about it. And it's very, I think it's very this distinction again between successful and successful mediation, something I don't really agree with. There might be a very narrow gap which has not been able to be bridged. That's why there could not be a settlement. But the mediator has pushed this process. The mediators has got the parties to has triggered off that movement, which eventually, even without the mediation, the parties may eventually settle outside the process. So there's no question where I would say a successful mediation or non-successful mediation, that should not be the criteria for pegging the fees and so forth, so forth. A mediator has spent time on a case, he or she should be given, in many of the institutional mediations like FICCI or PhD, etc., there's a slab. This is the value of the case or the amount involved in a case, then this will be the slab of the mediation fee, mediator's fee. So that could be one criteria, as opposed to depending on whether there was a settlement or no settlement at that moment. So that could be one aspect of it. Um, Commercial courts that you mentioned, I have my differences again about, because to the extent that, uh, like the bill, it also talks about mandatory institutional mediation. That you must have I mean, a Commercial Courts Act, it is, the provision is that if there's nothing urgent in a case, you must first try mediation, which is slightly different from the mediation bill, which says you have to go for mediation if it's a fit case for mediation. It's not in the excluded category, but you have to go for mediation and sit there for at least 2 sittings. Hopefully, you'll get converted. And if you don't, you can be visited with cost if the matter comes to court. So they're slightly different, but the element of coercion is there of sending parties to mediation before getting access to court. And to that extent, I'm against it, because not every case may be ripe for mediation right up front. There might have to be litigation fatigue. Not every case is ready for mediation when emotions are very high. You need a cooling off period. So some cases can be resolved upfront, some can't be resolved upfront. And if you take a situation with my experience or the my whatever I've read up about Commercial Courts Act, is a lot of people are just going there for the sake of a formality. They go, mark their presence, say we don't want mediation, come back and move the court. So you're spending your resources, you're spending time for access is something like, you just a person needs to cross one hurdle or jump one gate to get into court, and that will damage mediation in the long run. So I have slightly different issues, but that does get tied up again with the fees, etc. Because if you think about it, if the sheer volume of cases that will go for mediation, if it's made mandatory across the board, and then you need to have full-time mediators who would be doing only that work, volume would necessarily mean lesser fee. So this, all these things are interlinked. I mean, I would go conceptually to say that I would actually borrow what we use in institutional mediations, that a mediator should be able to charge fees depending on the value of the mediation and depending on the work involved in that mediation.
Yeah, I
If it's
think
a mediation going into months and months, because I don't buy this argument that do mediation 2 or 3 sittings. Many times it takes much more longer time. You need to let parties decondition. You need to let parties, ventilate, sleep over it for time to get over the trauma. So if that is the situation, if a mediator is investing months on a case, then the mediator must be paid accordingly.
because I think the volume of matters, I think that maybe has not come into consideration. Maybe legislation has been looked at from various places, and let's pick up from here. Like Rafaela was talking about the Italian model. Somewhere else there's something else. Let's put it all together. It seems like some kind of an activity, not looking at the situation as to actually numbers. Because look, for me, the important thing is that there is a whole process of certification in some countries and accreditations and all that process is happening. And when I look at it and I look at the way, I mean, so the size of India and the number of disputes in India itself, who are those people you will go and certify and how do you do it? For me, of course, I have an issue with can you do it? That's another question altogether. But
Yeah.
in terms of the volumes, the numbers that you have, I mean, if you look at just the 18 million matters that go into courts every year, and of course how many of them are the ones which will under this bill X bill were going to go for mediation, how many, and those numbers I will not have those statistics, and out of those 18 million how much would have gone into this process, but they will be in millions. So which means for those millions you will need that many number of mediators available somewhere. So are we, first of all, do we have that? I don't think so, but you will tell me more about that. So they don't, we don't have that. Then if we do have them, how are we actually churning them out? Is it a factory that we are creating, a 40-hour factories we are creating? Are we going into a different direction? Because personally, I have spoken about it a number of times. I don't think that factory concept really works. For me, a mediator has lots more as them. And to say that that 40-hour factory will actually make a mediator, I have my, I have those issues and I've spoken about that. So, I mean, I'm not, you are, of course, you will tell us about that, about this aspect. But just look at it from that perspective, from an Indian perspective. We look at it from the Indian perspective. How do you look at that aspect, which is now being done in a lot of countries? This whole thing pushing them into a mediation, and they have to go there now. Second stage, whether you went into it in good faith or not. We were just talking to Rafaela about it in Italy. There's a new legislation, the aspect of good faith, whether you went into that mediation, who decides good faith and all. So it's going into absurd and more absurd and more absurd direction. So something on this aspect, Aman.
You see, I mean, I agree with you. I myself don't agree that a 40-hour training will make a person necessarily a good mediator, and the issue of certification. But I mean, I have a broader issue. My broader issue is that mediation is a practice of law, but it's not only a practice of law. Anybody can be a mediator, as it was being mentioned earlier, and you may have people who are accountants, scientists, child counselors, etc. And which also brings into issues of ethics, ethical standards. We're talking about certification. How are you going to maintain ethical standards? What, as a lawyer, I cannot solicit work, even if I'm a mediator. But if there's a child counselor as a mediator, can that person solicit work? Whose ethic? It's a multidisciplinary approach, particularly when you're doing your reality check, you're assessing the strength and weakness of a case, you're trying to see the role of a lawyer, the problem solver, you're trying to see non-legal options for resolution, you're doing evaluation, you're giving suggestions, you're going beyond what a lawyer does. How do you ensure quality? How do you ensure accountability? Because mediation is a multidisciplinary approach. Do we need another way of having multidisciplinary ethical standards to govern mediators before you give certifications? So for me, it's a broader issue. I mean, like, to give a very small example, as a lawyer, I cannot speak to the other side's client. It would be professionally improper. But in mediation, one of my favorite techniques is to tell the lawyer of party A to speak to party B and tell the lawyer of party B to speak to party A. So when your roles are different, and it's, when you talk about good faith of parties is one thing. What about the good faith of the mediator? Many times a mediator it's not a question. Mediators always may or may not be acting in good faith. One can't trust the goodness of a person. But even if a mediator is acting in good faith, the approach may be different. A mediator may think, is this expeditious, or is this the best deal, or is this a fair deal, or is it something the which in my assessment will preserve relationships. The factors to let the mediator adopt a particular approach in mediation, even if it's acting in good faith, may vary from mediator to mediator. And then you have multiple kind of permutation combinations of ADRs. So this is this whole debate of what should be, if you're talking about certification, talking about the skills, you're talking about accreditation, you're talking about the quality of mediators. We yet to have a consensus of what should be the ethical standards of a mediator. Because many times mediators does compromise neutrality. If there's a power imbalance, a mediator will compromise neutrality to move the power balance.
Which is what I
If
had a
there
whole
is a question,
symposium. I had also a whole symposium on neutrality and mediation. We actually discussed these aspects. So please,
yes.
if you get time, please watch those sessions. Very interesting sessions.
So when there could be a repeat player, I might be a mediator with one party. A is common in 4 or 5 early mediations. That somewhere neutrality will be compromised. So where are the ethical standards? So I mean, of course, I'm glad to watch the symposiums on the issue of neutrality, etc. But for me, the broader issue is we have yet to have a consensus of what are the ethical standards that should govern mediation. We do have some standards which were examined by the Supreme Court in Salem Bar's case. So the model rules, you have those 12, 15 code of ethics which are there for mediators, which in my view, again, are not adequate given the role of a mediator. Because unlike a lawyer who's bound by loyalty, etc., or representation, a mediator is not representing a party, a participant, if you want to use those words now. So, so basically, I mean, so this is a broader issue. It is about many layers. It's far more complex than simply having a legislation which says
Wow.
everybody should go for mediation before you want to go in a commercial court case. Before you want to approach a court, infrastructure, training, etc. is one aspect. But who are those mediators who are and for Commercial Courts Act, even for the final bill, there's this mediation bill, they're talking about authorities under the Legal Service Authorities Act. And then you might have qualifications, etc. But where are those people?
Exactly. So I'll tell you how I look at it, because this is the way I'm taking it forward. Of course, all these symposia that I've had, there have been reasons for it. So it started with mediation in our culture and traditions, so that people might not be familiar with the word, but they're familiar with the process. Let's connect them with the process. If we connect them with the process, we also connect them with those people who are actually doing it on the ground. There are individuals there everywhere who have that mindset and are actually doing the work on the ground. Let's identify those people, because those are the people, for me, are the ones who are the mediators, because the people in that community, in families and everyone, are actually using them. So for me, only people who can make mediators are the people in dispute. They can make anyone a mediator. And the moment that choice is not left to them, then we've already gone against the concept of mediation for me. So that's the starting point. So we did that. Then, of course, the other aspects of what all does it take to be a mediator? I mean, what all do we even know that? To say that I will certify you, do I even know what am I certifying? So I had this next symposium was on heart, soul, spirituality, and mediation. So those are elements which you might not have today words for, theory for. You don't have that. Maybe you don't know what's really happening there. What is this the dynamics in a mediation? What all the energies and everything that are there? Maybe you don't even know that. So how do we really? I mean, are we in that position to even say, even certify as a very, I mean, major thing, to even say that this as person can or cannot be a mediator? So I think so. That was what. Then, of course, the indigenous peoples and mediation was basically on this aspect of, again, that what has really been happening, and don't just say, okay, in communities it used to be there. No, dig deeper. Was it arbitration or was it mediation? Distinguish the two. Do not connect people to a word which actually might be arbitration in that light. So like panchayat, I have a big issue when even the Supreme Court training manual puts the word that it connects panchayat and mediation, while on the ground a villager for the panchayat gives decisions. That's in their mind. That's what a panchayat does. So you're connecting them with a word with taking a decision. And he said, now this is another guy who's going to come and take a decision for us. Might as well go to the court. I'm just thinking from their mind what's happening. So we have to be careful, very careful, because every language, every country will have the word which is used, but that word also which for how do people perceive it. So we did that. Then colonization and decolonization and mediation. I feel this is a colonial concept. First of all, legislating everything and and then sometimes over legislating. I think it's just a colonial thing that we want to, in some way, have control. And I'm saying that what are you trying to control? I mean, this is their process, their empowerment as people. But what we are going to discuss, what you're going to put across is what for you should a legislation look like? I mean, if we have a structure conciliation, you want to look at that, or you look at the model law, not or disregard all of them. But you have to tell us what you feel should be the legislation for mediation. We're looking at India, and the same thing should apply everywhere. So of course, we'll also discuss this in the workshop on the 19th. But what would your structure be?
No, I would actually start the use of base of the Conciliation Act, which I think is far more liberal than what we have. The mediation bill is diluting confidentiality, diluting party autonomy, voluntary nature. So I would throw that out completely. Stick with the Conciliation Act, make it applicable even to the court annex mediations or institutional mediations. Build on it to bring about accountability and quality ethical, the way I was talking about, because mediation is being, that cloak of confidentiality makes it a private practice, and is far more dangerous to have a bad private practice, something happening in the cloak of confidentiality. People won't even know about it. So, I mean, when arbitration is maybe in closed doors, but there's still a public element attached to it, you at least have the parties, private sessions there. A court is supposed to be open court, so that's ventilation. But mediation can be with caucuses, etc. It can lead, you can perpetuate bad practices without the mediator, an unethical mediator or an unethical participant getting caught, or be made accountable for what they're doing. So that's the reason we do definitely need some standards of conduct. We need some disciplinary body where there can be a complaint. Just disempaneling a person is not good enough if there's a breach of the rules of mediation. You need to have some system of accrediting a mediator, some basic trainings, not necessarily be on in terms of theory, etc., but with the skill building, etc. I mean, I would be against what we have of registering settlement agreements, because you can't put a settlement agreement in the public domain. The whole incentive of settling is people don't know the terms of a settlement. For MNCs who want to protect proprietary rights in software, they don't want that in public domain. For celebrities, they don't want to know how much alimony they paid. So why should this be in the public domain? That's the reason why I would simply build on the Conciliation Act and add to that few things which gives a kind of institutional framework, some regulatory framework to mediation and conciliation. So that's what I would actually go for. And of course, I mean, one can keep adding to it, altering it depending how the experience goes. But I would not make it mandatory. I wouldn't put a time limit on it. I would not, like I said, put the onus of even get it registered. I would not dilute confidentiality, even if it involves a misconduct for mediator. For mediators misconducting himself, terminate the mediation. That's no ground for violating or removing confidentiality. I would not give exceptions for cases of domestic violence or abuse, because if you make those kind of mediations non-confidential, nobody's going to come for mediation. In mediation, if you're trying to break the conflict cycle, you're trying to get into the innermost thoughts of a person, they are never going to disclose their vulnerabilities or even incriminatory material if they feel whatever we are going to say is not confidential and will find its way to the judge, who can decide the case against me based on what I've said in mediation. And that's the reason why I disagree with the Supreme Court's decision in Perry Kansagra's case, for instance, where they say that mediation confidentiality is not attracted for cases relating to child custody guardianship. A guardian judge should have everything, every material related to a child, even if it's in mediation. I disagree with that, because mediation is not an expert opinion process or a discovery process. Why would a parent bring a child for mediation if the if the parent feels that a child counselor may give a report, one-sided report, which will go to the judge to be used against that party? So that parent may simply say, I'm not bringing the child. You go to a court to say, tell the parent to bring the child. The court orders that to take the child to the mediation center. If it's a court order, there's an element of coercion, mediation is over. Party will stop going for mediation. So I would not dilute confidentiality the way it's sought to be diluted. I would not dilute voluntary nature. I would not dilute self-determination, party autonomy. I would talk about I would add things on online mediation, which is not mediation necessarily in the virtual setting. Today, mediation can be used as a better alternative to arbitration litigation for disputes arising, say, out of smart contracts, where you have the technology intersecting with the commercial world. You have a lot of issues to talk about the applicable law, whenever using the blockchain technology, for instance, which is who are the parties to that transaction, which should be the applicable law, how do you fix accountability, rather than getting into that, getting into digital signatures, trying to prove them, etc. You can use mediation. So you can have mediation which talks about identifying a mediator should there be a difference, giving that mediator predetermined access to the blockchain, that should there be a settlement, the mediator can code in the settlement. You can have automated enforcement of mediated settlement agreements with, I mean, you can have your virtual currency going from A to B through the blockchain, should there be a settlement agreement. So there's a whole world out there for commercial disputes where mediation is a better option. So you need to have a statute, you're talking about a digital rupee, talking about virtual currency. You need to have a legislation which talks about online mediation in this sense, not mediation in a virtual setting. So they're huge. I mean, you need to have a set mediation agreement law which talks about non-commercial disputes relating to the government, which is excluded from this bill. Non-commercial international disputes. There's a huge area. I mean, if this is just some of the thoughts on the just off the cuff, but if one goes into it, there's a huge amount of things that can be built upon the existing Conciliation Act, as opposed to the incoherent mediation bill we have. And that's the kind of legislation I think we should be looking for in future.
But the thing is that my hope was, because you were there and you were talking to these people, you would be able to bring some sense into the whole thing. I hope you've already done that. I'm sure they will look at it. But only there are some things which I differ from you. So, but I'll get to that after I ask you, whatever legislation you look at, please look at it from the perspective of a villager sitting in some remote part of this country. For in their connection, how would you look at that legislation and all these things that you mentioned? What may you say maybe is not required? Just for a moment, just you're going out of Delhi totally. Now you've gone into some corner. Now look at it from that setup.
No, you see, the thing is, first of all, of course, I mentioned all these things to the parliamentary committee, and I'm glad to say the parliamentary committee has accepted these recommendations on not making mediation mandatory. They've talked about the issues of the distinction between court annex and private mediation, about having a time limit for mediation. This is, we don't need one. About challenging settlement agreements on the ground of fraud, etc. And it's ridiculous that you have a provision which says that your limitation will start from the time you receive a certified copy of the settlement agreement. A, a limitation, first of all, fraud unravels everything, vitiates everything. But even if you have to have a limitation, it starts on the discovery of the fraud, not a predetermined event like receiving a certified copy. So the committee has gone through all these points. They have made some suggestions, which is there on the website, and that's the reason the bill is not going. The law is not going to be in the same form in which the bill is. So that I'm quite confident about that. But coming to your question of seeing from the village point of view, you see, the thing is that a legislation has to uh, be comprehensive enough to cater to every situation, every target audience, if you want to put it that way. We do, if you really do want to have, which this bill is trying to do, have a separate provision for community mediation, get people from, respectable people from the village, for instance, to be part of that panel of mediators, people whose, because of their respectable stature, would be able to persuade villagers to come to a settlement. There are many ideas which are floating around. I'm not necessarily endorsing them, but there are many ideas which are floating around, and that you should have a provision at the village level. For me, the legislation is mainly to regulate the practice of mediation for those who are professing to be mediators. Because being a confidential private process, it is capable of misuse, whether it's a big city or it's a village. So for me, certain parameters have to be laid down that a mediator cannot impose a settlement. The mediation bill does not say so in its definition clause. It
Exactly. We've
borrows from
changed that, yeah.
Singapore Convention.
But
It does not
it
even
deletes that.
say that a mediator definition does not even specify a mediator cannot impose a settlement agreement. Rather, Section 18, if I remember correctly, simply goes around saying in clause 2, very loosely worded, a mediator shall inform the parties that he may not impose a settlement agreement. So you conceptually, the legislation must be very clear about what is mediation, the role of a mediator, how what is the process of mediation, the standards of mediation, the ethical conduct to be followed, the regulatory framework, and of course, uh, try to mainstream mediation by more innovative methods, by creating awareness about the benefits of mediation, etc., rather than making it mandatory that you have to sit through, even if you're unwilling for mediation, you have to sit through two mediation settings, even if you don't want to. So there have to be more innovative methods of mainstreaming mediation so it reaches the grassroots level so that people feel that yes, this is the cheap, expedient, convenient way of resolving disputes. Incidentally, that was the whole idea behind Grand Nyala's Act, which is not taken off in the country again. But the whole idea was there was no schedule of cases, civil cases of certain kind, criminal cases of certain kind, which could be tackled at the village level itself. So we need to strengthen, decentralize. We need to strengthen the village level bodies, get trained people out there. I do take a point that it's not necessarily training that makes a good mediator, but at least some do's and don'ts is required. Some skills are required. Some
I'll
capacity building is required. So I'm not completely, I mean, I for one have my own views about the kind of training that ought to be imparted, the curriculum that should be there, the teaching method that should be used. We are using very outdated teaching methods. Our curriculum is not updated. In India, we don't even teach dispute analysis, remediation dispute analysis in our curriculums. We don't teach restorative justice practices when we're talking about mediation.
yeah.
Our curriculum is outdated. So a lot of other things need to be added on. So I'm not against training. I'm against the kind of training we have right now in the country.
Yeah, which is the scary part because like it's very easy to say that there will be under the law, there's a provision that you have certified mediators. Now, what is really happening there? What are they being told? I'm telling you this, I keep giving this example of the word neutral itself. I'm saying 40 hours, you can just have a discussion on neutrality and mediation. Of course, we've done a number of hours in that symposium, that by
Yeah.
itself. But because you don't have that time, you tell people a mediator is neutral. Now take this and go away. It's much more involved in that. But from the village perspective, why I was asking you is because, of course, again, this is I'm saying this is a colonial concept that we will create a panel like it's done in this X bill. We create a panel of people and the SDM or whoever can do it. Well, that's a colonial concept. The villager or in the town concept is the same. There is no difference in relation to what provisions they need. And what you just said, the conciliation provisions are as good for a village as it is good for a city, big city. It makes no distinction, and it is not no distinction required. Main thing is that you sitting in a village can get a court decree. I just put it that way because how it is, it's a consent award and all that. We don't have to get into it. You get a court decree sitting in your village. Anything else that you regulate, I mean, I look, like you said, online aspect is something which there was some regulation that was being discussed on that. Anything else, if it
Yeah,
is,
but for me, for village, I think what is crucial is restorative justice. You see, because take a situation, young boys burn down a bridge in a village. Now, if you want to do a kind of conciliation or mediation in restorative justice, we don't see whose fault it was. We see harm has been caused. What will it take to cause that, repair that harm? So if these boys are express regret, they regret what they've done, they want to apologize. One way of setting things right is for the boys to rebuild the bridge. So in a village where community level, community relations are paramount, where you try to have harmonious relationships, salvaging a good relationship between people, there we must have techniques by which you can bring a closure to the emotional trauma, you can restore or repair the harm which is caused. That is something which is, I think, far more distinctive in villages, far more crucial in villages as opposed to a commercial dispute between MNCs.
Yeah, yeah.
It's also important there to have a good working relationship. But I think what we are, the people who are there in the village must be trained in techniques of how to handle trauma, how to rebuild relations.
Right,
So,
and
and that is a slightly different role than the kind of, whether you call it opening statement or orientation, I don't call it either. I'd say it's a conversation. You set a tone with your conversation. It's not a speech you're giving to a person.
absolutely.
So, in that conversation which you're giving as a mediator, if you're giving as a mediator, it is slightly different from the conversation which you're starting as a restorative justice practitioner, a third party neutral there, who is trying to get parties to emote as to what had happened, how did they feel what had happened, they saw what had happened, how has it impacted everybody else's life, what can they do to make things right. So there's a different technique of doing that.
Right, and
That is something I think should be there in the village level, definitely.
but you're accepting my participants or not? You orientation we don't want it, but participants, please, because every time I hear parties,
I'm
I
happy to use participants. I mean,
it's
you
it's
see,
just
I think the parties comes more from the point of view of saying it's party-centered process, where it is litigants, because, like I say, I'm associated mainly with court and litigation, and where we use party in contradistinction with plaintiff or defendant,
yeah.
that we don't, I see who initiated the issue process, all of you are the same in mediation. So I'm happy to use participant, I'm happy to use even a more neutral thing or simply address people by the names rather than by talking about the positions, whatever it is. So I'm okay with that, whatever it takes to make the process more even handed and more centered towards the people who have to take a decision themselves. So I'm okay to use any of those things.
Well, I'll tell you what. I mean, I'll take you through what I think what we about how I'm trying to create that. I mean, in my little way, whatever the thoughts I have, because the difference is like Rafaela, of course, is in a country where the population is 60 million. That whole country has a population of 60 million, and Rafaela will, of course, be shocked at what our population is. But Rafaela, please, one guess: what is our population? What is the population of India? Without googling it, you have to just give a answer like that. What is it, Rafaela? How much? What is the population of India? Without
Um,
googling, no googling, okay?
I don't know. I leave Dr. Anand to Aman to reply to your
No,
question.
what is your guess? He knows the figure. What is your guess? Because I'll tell you why I'm going to get to it. Because I'm going to look at it from the perspective that you spoke about. Mandatory mediation, part of it was largely what you were speaking about in Italy. I'll just
No,
connect.
I have
Just a
no.
guess. I told you, Italy is 60 million. How many you think in India? What is the population?
Percentage?
No, just what is the population? Okay,
A figure.
you don't want to give it a figure. You might be wrong. That's why you don't
Yeah,
want to give the figure.
completely,
Okay,
completely
totally
wrong.
wrong.
I
Okay,
will be
so
massive
we have
figure.
1.4 billion people. Okay, you have 60 million. So to say that what works for Italy
Wow.
is going to work for India is a big issue that I have. The way we've tried to take from places which I have no comparison to our country. 1.4 billion and 60 million. I mean, come off it. Let's not even go to. So what I'm trying to say from the village perspective for me, and this is same everywhere. What I'm trying to do is let's identify those people who already are doing mediations because they're already doing it. It's all there. Don't connect them because you like whatever you say awareness of mediation. I have spoken to people who have gone out and in some way attended these awareness things. And what do they tell me? Again, the same thing. They connected it with panchayat. That's what they tell me. And then I have to, one discussion, I have to tell them, no, they don't take a decision for you. Then the conversation starts. Then they tell me, give me the names of those people in their village. So those people exist. So first is identifying them. If you say that you people, of course, Rafaela also teaches, you also teach, and I, of course, I'm to use the word skill development, not teaching, but I'm saying, can we not put it all out there on YouTube? You people have a concern that some basics should be available to them. They already have the practice. They don't need any mock mediations or anything. They're actually doing it. So the user experience is already being given by them. We can create whatever skill development program, which I'm doing, which I'll get both of you involved in also. We will have these modules available for people to access. So we, at least this goes out of the mind that, oh, we haven't given them this kind of input. And if we had given this input, they would have been different. Let's give them those inputs. So because on the other end, I mean, in some way criticizing the whole training part. So we give them that skill development modules are available, practice they're already doing. So, and this is not just in villages. I mean, in anywhere, cities, towns, countries, I mean, the city, large cities, small cities, everywhere. So, and which is everywhere in Italy or India or anywhere. So these people are identified. User experience is guaranteed because people are trusting them already. Because the important thing that has come out in all our discussions always is trust. And that trust word comes from so many factors. To even pinpoint it to one particular thing cannot be done. So trust. Whom do you trust? And once you trust that person, all these other issues that keep coming up on standards and everything will not even be required because it is their person. They trust that person. The only problem is that that whole kind of an ecosystem has not been created where people know about these people, but they are now hidden somewhere. They're doing it in their small pockets. But if we get these people and there is a platform where their names are available, their contact details are available, you get in touch with these people, local or go online. You can, someone from India can have someone from Italy doing mediations, and our legislation should support that. The problem that is happening is countries want to legislate mediation, whereas it is not something which is actually, how do you stop me from talking to someone in Italy and saying, please help us resolve this? How do you do that? Why should you do it also? So that colonization concept of wanting to control this thing, I think luckily Singapore Convention went beyond that. Wherever you do the mediation, however you do it, it will be enforceable in a country which has ratified it. And that is what I'm saying on a global level or on a domestic level. Concept should be the same. Wherever you do your mediation, whoever you take as your mediator, not the concern. At the end of that settlement agreement, you should be able to enforce it anywhere. So I think that's the framework I would want. I mean, so in that kind of a context, you have to tell me what is that, what should that legislation look like? That will, because if this doesn't support it, I'm trying to do this at a grassroots level all over the world, and if the legislation doesn't support it and it comes in the way and says no, only these people, certified people, can do the mediation, then it's gone against the whole grassroots movement. So those are my concerns. So your comments, Aman, then we'll get Rafaela's comment on it.
No, I mean, I agree with you. I mean, anyone who I would say um, has the skills of doing mediation, I still emphasize on the skills, can be a mediator, and there should be no embargo on that person doing mediation, and what comes out of the settlement agreement should be enforceable as a decree of a court is with the consent of the parties. I have no problem with that, and which is the reason why I say you can't have these artificial distinctions. For community mediation, it will not be a decree of a court. Why not? What's the incentive of getting into mediation in the first place then? And so you must have standardized, but to be able for that, you see, the reason why I emphasize on skills is if it's got to be a decree of a court, drafting a settlement agreement itself is a performance skill. It has to be executable, it has to be complete, it has to be practicable, it has to be within the parameters of the law. It has to be positive, it should not have a blame assessment. It can't use ambiguous words. Who will do what in how much time, in what manner. So a person needs to be trained in doing this thing. So, which is the reason why I still emphasize on the point that if a person has the requisite skills, that person can be a mediator, must be a mediator, and whatever comes out should be enforceable as a decree of a court, regardless of whether it's in the village or in the town or the city or the capital or wherever it is. And the legislation should support that. There's no two things about it.
Okay, so only concern that I need to address is on the drafting of the settlement agreement. So we can talk about that, but we'll get into that. Yeah, I think that's the only little thing.
Drafting is only one aspect because
No, everything else you agree with. It's only that
Very-
little.
no, even drafting, you see, draft skills are You see, where there's advocacy, where there's mediation, where we talk about any of these, I see them as performance skills. You can have theory as much as you want to, but when you're actually in the hot seat and you have to perform, you should be able to perform. You should need the skills to perform.
What is written into the agreement, because that's the problem. The bigger issue about the Singapore Convention, the signature, the ratification, it's about the final written agreement and how it can be performed or enforced into different states. If the agreement is an agreement that the parties really wanted, they will spontaneously comply with what they have agreed in written words. But the problem arises once one of the parties does not want to perform the obligation he or she had signed. And I agree with you, Vikram, that everybody can be a mediator, can help parties to sign a settlement agreement, okay? And so mediate for the parties. But it will be just a contract, as Dr. Aman said earlier on. It's okay. It's private. It's the freedom of the parties. They can do that. But at the end, they'll have a contract. And a contract to be enforced, will need a lawsuit if one of the parties wants spontaneously perform the obligation. And that's the crucial issue the legislation are trying to rule, because otherwise it will fall under the umbrella of just a contract, and parties will be back. And in addition to that, while they're negotiating, knowing that they're just signing a contract, they won't feel safe. They won't feel protected, because if they're trying to settle, it's because they are in a dispute, so they don't trust each other. If we just sign a contract, okay, I will do that for you. Okay, I will deliver the goods within 30 months. We just sign the contract. Thank you very much. Shake hands, and then I don't know if I can trust.
No, but Rafael, no, Aman is saying that
So
it should have. No, he's saying. No, he's saying that, and that's what you're saying, that is not a contract. It's as good as a court decree, or it is enforceable as a court decree. That's what he's saying. He's not saying that. The point is that, first of all, anyone can't be a mediator.
Talking about legislation.
No, in legislation only. That legislation, it should be as good as a court decree. It should be enforceable as a court decree. So that's that thing. It's just a contract should not be the case. The only difference is that certain jurisdictions like Italy feel only when you sit with these certified mediators, that particular settlement agreement is enforceable as a court decree, and not the ones that you sit with, which are not the certified mediators, which is what the distinction that I'm trying to make. And I think Aman is also maybe saying that whoever it might be, it is your mediator, you trust the person. At the end of the day, if you have come and you settle something, that should be enforceable as a court decree. The only thing here, I mean, the little bit in terms of the structuring of the agreement is what we're talking about. One aspect is that we can put formats in that legislation, that this is kind of what the format is. The other thing is that we are three lawyers sitting and talking about it, but we should not for a moment not look at ourselves as the mediators and doing this work. Lawyers are always available to draft the final settlement agreement. Terms of it can happen with a mediator who's not a lawyer. I mean, there will be all kinds of.
In Italy, we can do that under the negotiation legislation.
Yeah. So
but still, there are some guarantees to provided by law to give parties some guarantees that the procedure is governed by law, which requires some guarantees for the lawyers to comply with. It's just for the guarantees for the parties.
Yeah, well, how I'm looking. No, that's why I first had to start with giving you the scale. 1.4 billion people. I want to keep them away from lawyers. Okay, so that's my starting point. And no, because I tell you why. Again, I did not ask you for another figure. I will ask you to guess. how many matters are pending in courts in India?
Lawyers are the good guys.
No, I'll tell you the good guys. I'll talk about the good guys. One thing, Rafaela, your answer this time. Try and guess how many matters are pending in courts in India. One guess. Rafaela, any guess? Okay.
Oh God, maybe less than in Italy.
How many? Any guess? Just fast, quick guess. Anything?
500,000.
50 million. Okay. There is enough work for lawyers to do in courts. Keep them in courts, keep them busy in courts. 50 million, and it's not decreasing because 18 million.
The entire population of Italy.
Exactly. So, I mean, if you are not, I mean, nothing close to what's happening. So, if you look, so let's look at it from this perspective that there is enough work for lawyers in courts. Here, there are enough people who have that mediator mindset. We have to strengthen that because lawyers, if they are going to take out time, okay, I have a matter in the court, in between I have 1 hour, come, I'll do mediation. That's not the way mediation will progress. We need people to take it up as their, I won't say profession because I've had debates on this, whether it is a profession or a way of life or whatever, but take it as their livelihood. We need people like that, which would be from every background. They don't have to be educated also. Education doesn't make you a mediator or give you the mediator mindset. It is something, there's lots more that has happening, and there are people who can do that. So I don't even look at education from that perspective, but you have to strengthen that, make that kind of a whole, I mean, culture where those people first of all are there, and then after that strengthen it with legislation. And of course, I'm saying that legislation we already have, so we already have a very nice legislation. We don't need anything better. Aman will tweak it a little bit for all little things that and those are easy to be tweaked, and little bit of a format he will put for that person in the village can actually, he knows he has to fill this up, and we don't have to be stuck with the word mediation first of all. And I keep telling Aman, I keep telling everyone, the translation of that conciliation into Hindi is Sulh. People connect with that word. That's the translation of the language, our act itself. So we are not stuck with the word mediation. It is between the mediation world we had to come with a common word to debate. But the common word that in Italy that people understand, let's connect them with that word. In say in Hindi. Hindi is just one language in India. That our act, when it's translated into that, uses the word Sulh, which people understand as a process where someone is getting you to settle something. Similarly, in every language in India, everywhere in the world, those words are available. So let's not, I mean, let's connect them to that part. And of course, legislation should strengthen it. And of course, Aman has to go. So he's going to conclude, give us concluding remarks. And then Rafaela can maybe sum it up also. So, Aman, how do you want to conclude?
No, I mean, for me, I think whatever word you want to use for it, whether it's conciliation, mediation, Sulh, whatever it is, I think it is the way forward. It is the way forward for conflict resolution. And I don't see, I mean, for me, I would put more and more cases that can be resolved through mediation as opposed to, putting a list of excluded matters the way we have right now. I would like to enlarge the scope of mediation. I think it is the way forward. The judiciary in India is wholeheartedly supporting it, and which is fortunate because that's, once you get one institution of the government pushing something, then that itself gives a lot of credibilities. Or we on the subcontinent do tend to have the unflinching faith on courts. We always say we'll meet you in court. So once the court gives its support to this mechanism of transforming conflict, I think it has its own credibility. So the future is, of course, mediation, conciliation, or SOLA, whatever you want to call it. I just feel that it's a question of time when most lawyers will also tend towards going through mediation. In big cities, we charge more heavily for attending mediation or doing mediation than a court appearance. But that is still to catch up with the rest of the country. There's still opposition in many places to this whole process. And I think, once we mainstream it, once it becomes the preferred mode of resolving conflict, hopefully a lot of that burden which Vikram was mentioning on the courts will go away and our system will become more efficient also. So with that, I conclude whatever I wanted to say. Lovely talking to you, Rafaela, and of course to Vikram as always. And we meet again at another time.
Yes, and when we see the new bill, we will
Thank
know
you
that
very
Aman
much.
has been able to influence that. So please, Aman, We need you to, the new bill should come out in a very nice, simple way, which I hope you can influence. So,
Hopefully, let's see.
thank you very much.
Thank
And
you.
see you on the 19th, please. 19th, please
Thank
keep some time on the 19th.
Thank you,
Good.
Vikram. Thank you.
Thank you, Rafaela.
Thank
Nice
you
meeting
very
you.
much.
And we'll 19th, please, both of you do try and attend that, right? The workshop. Rafaela, you know about the workshop?
Yeah, I will check on it.
Yeah, and try and if you can watch some sessions, please watch some
I
things
will.
and then we
I
can.
will
Thank
do.
you very much. See you.
Thank you. Bye.
Pleasure.
Bye. Bye.